circle risk regulation was a little bit like this because I wanted to explain it to audience that might not know anything about it. It's a technical subject.
Okay. Did you outline the book before actually writing it?
Yes.
Why is outlining important?
Outline without outlining, you don't know where you're going. I mean, I have to, people will read something, they want to understand what the basic point is. And people take in, I think, writing normally, where it's not, you could have purely aesthetic writing, just designed to create an overall emotional impression. But lawyers or judges are not rarely involved in that. They're involved in trying to explain something to someone. And people can only grasp a certain number of things. And so the way that I think you get people to understand something is you have a broad outline, and then you fill in the details like a tree. And they can understand it once they see the tree. But if you don't outline it, they will never see it, because you won't see it yourself.
Are you a natural outliner?
Yes. I mean, in other words, do you think I just normally do that? Yes, I normally do that. Always. Always. I always have an idea just where I'm going.
Do you think it's universally true that writers of nonfiction would benefit from doing outlines first? I mean, you must see what happens when people don't have outlines.
Right, when you don't have outlines, you don't know where they're going. Now, if you're a genius, I suppose, that it wouldn't matter that much. I mean, you get something, you really look at Montesquieu, or you really look at Wittgenstein, or he's thinking of something up here and something over there, and it's what was called a pensée. It's like Walt Whitman's Leaves of Grass. I mean, you have leaves of grass, and they grow, and as long as you're a genius, I'm sure it works fine. But for most of us who are not geniuses and cannot expect your reader to be absolutely fascinated by every idea that comes into our heads, I think for such a person, you have to have a definite outline of where you're going. It needn't be long. It has to be enough to keep you on track. Sometimes I could have an outline of something I wanted to say. The thing is quite long, but it's like 8 words. But these 8 words are going to keep me on the track.
Okay, your outline should be longer than 8 words. So take a moment, just take about a minute, talk to the person next to you about your thoughts about what Justice Breyer has to say. And as I said, we're just kind of dipping our toe into the outlining waters here. We're going to read Brian Garner's description of how to kind of outline in detail. But take about a minute, just talk to the person next to you on any thoughts, anything that surprised you, and then we'll share.
You talked about how we were shocked that his outline is only 8 words.
Did he say that it's always only 8 words?
Well, no, he said even if it is 8 words, that helps.
Yes. Michaela, do you think I showed you the clip in order to encourage you to do an 8-word outline?
No, I think you showed it to us to show us that outlining is important.
Yes. And that, it's not a sign of not being a good writer or not being like it's not like, oh, I'm not good enough to do this without an outline. Good. Any other thoughts, reactions, surprises? Yeah, Emily.
It was nice seeing someone explaining outline much better than when an undergrad in high school it was a lot of because I said so. I really didn't outline a lot because it felt like because the teacher says so.
Good.
So
Well,
this actually makes me want to.
I'm thrilled. That makes me happy. That makes my day because I always try to explain to you why we're doing what we're doing. And I'll just give you a little preview because I love the Garner section on outlining. I think we talked about this before. I'm a huge outliner. I spend more time researching an outline than I do actually writing. My wife, the opposite. She writes terrifically, and she does the research, but then she just kind of plows into it and goes from there. So Garner says that there are 4 stages, it's like 5 stages of grief, whatever. There are 4 stages of writing. And so his first stage is the madman stage. And that's where you're doing your research and you're just kind of like trying to figure out, okay, what ideas make the most sense. I'm going to just make lists and accumulate as much, I think in the kind of martial terms, as much ammunition as possible. And then later I'll decide, okay, where do I want to point the gun? All right, which bullets do I want to fire? And that's the madman phase. Then he's got the architect phase. And he explains in the reading kind of the value of this, but this is the outline. Right? You're building the structure. Right? And it's hard, it's dangerous to just start writing without kind of figuring out where you're going. And then he's got the carpenter phase. This is what most people think, or I would say most people, this is what many bad writers think is what writing's all about. The only thing writing is about. And that's just like actually, like, you know, putting words to paper, complete sentences, paragraphs, that kind of thing. It's important, but it's only one of 4 stages. Final stage is the judge phase. And this is an extremely important phase. This is where you edit and edit and edit. So when we listen to the Ta-Nehisi Coates description of his writing process earlier in the year, remember what he said. I put something down, carpenter phase, and then it stinks. And I come back to it the next day and I make it a little bit better. That's the judge phase. But it still kind of stinks, and then I come back to it the next day and I make it not so bad. And then I come back to it the next day and I edit and I edit and I edit. And then finally I've got something that's pretty good. And if you get there, that's a success. That's what he says a success is. So good, that to look forward to in the Garner reading. Do you have to do it exactly this way? No, right? You got to find what works for you. You have to find the structure, style that works for you. But especially if you're having trouble, give it a try. Okay, I'm going to do just a few minutes to prepare you for your Blue Book reading, because you open this and we've already talked about how to cite cases, short form and long form. Now we're going to talk about how to cite statutes. In particular, we're going to start with federal statutes. That'll be your reading for next class right here. But I don't want you to just like open this with no prep and be like, oh my gosh, this is like reading hieroglyphics or something. Okay. So citing federal statutes, actually pretty, I'd say, easier than a case. Okay? And here's an example. 28 U.S.C. section 1983, parentheses, 2012. That's the cite. And then if you wanted to use id, if you were going to cite it again in your very next citation, you just do id, like we learned. We learned, Phil, is the period underlined? Sorry, is the period italicized or not italicized?
No.
Oh, who wants to show of hands? Italicized or not italicized?
Wait, which one are you asking?
The period, is the period italicized or not?
It is, right? Yeah.
Yeah, sorry.
Okay.
Why? Somebody tell me why is this period italicized, whereas if I were going to do Smith v. Walker, comma, 12 U.S., blah, 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 that comma is not italicized. Yeah.
It's abbreviation.
Yeah, right. Why is so the period is part
of
say,
the word.
Spell it out for us.
Because it's an abbreviation, so as opposed to being something else outside of
Yes.
what you're citing, I guess.
This punctuation mark is not separating the abbreviated word from something else. This punctuation mark is part of the abbreviated word. And so since the abbreviated word gets italicized, punctuation mark also gets italicized. So id, if you wanted to just cite this exact section over again without an intervening cite, or let's say you wanted to cite 28 U.S.C. section 1981, right? Same title, different section, id section 1981, right? I went from 1983 to 1981. So long form, short form. Now, here's the only other thing I want to tell you before you read this. What do all these things mean? Why are they there? Well, when Congress passes a law, it doesn't call the law 28 U.S.C. section 1983. It calls it like Restore American Justice and Hope and Save the Trees Act, And so then they vote on it, it passes the House, it passes the Senate, the President signs it, the bill becomes a law. And then, only then, after that bill becomes a law, it gets codified in the U.S. Code. And that's really just a way of taking all the laws Congress passes and kind of just categorizing them so that they're kind of in the same code books as similar laws, criminal code or tax code, things like that. So this tells you the title, Title 28. USC stands for United States Code. Here's the section sign. There's a space here, and there's a space here. There's also a space here. That's more obvious. Section 1983 is this section. And then here's the last time it was codified. Whatever the most, you should find the most recent code and let the reader know what that was. And then as always, we end with a period. So Blue Book will go into more detail, but when you see these numbers, you're like, well, why, how did a law become this? It makes some sense. And if you actually went to the library and looked at all the books that are the US Code, there would be Title 27, Title 28, Title. Okay. Let's talk about research tips. Let's talk about research in general. You did a nice job with the homework assignment that you turned in. Everybody found the 3-part Brady test. Be careful that you don't stop reading before you should stop reading. So here's what I mean. So some people found a good treatise on criminal procedure. They found a description of Brady, which I think was from 1973. But in the original kind of iteration of Brady, there was a requirement, or at times a requirement, that the defense request the information, request the evidence. And over time, the court has tweaked Brady. And so now there's not an absolute requirement that the defense request the information. If the government has favorable information, has a duty to disclose that favorable information, whether it was requested by the defense or not. And if that favorable information was withheld, and if it's material, reasonable probability would change the outcome of the case, and there's a Brady violation, there's a due process violation. So a couple people just like describe the old Brady version with kind of thing about how the defense has to request. So just, you know, it's hard, especially as halfway through your first year of law school, to know, like, when am I done researching? It's hard for a junior attorney to know. It's hard for a mid-level attorney to know. But keep reading. Keep reading. At the very least, a good rule is if you're reading a treatise, once you think you have the answer, read the next page. Just make sure that the treatise is done discussing it. So how would you find it? How did you find a treatise? I'll start with Shelby. Tell us what treatise you found, or what secondary source you found to find the Brady test.
It was, I don't remember, criminal procedure book.
And how did you find it?
I asked the librarian.
Great, great. So one of the things we were trying to learn in this is not just how to use the books in the library, but also how to develop a good relationship with the human resources in the library. So let's imagine that I was assigned find a secondary source that has the Brady test, or let's say I wasn't assigned. Let's just say I'm a junior attorney. My client comes in and says, "Hey, you know, this Brady problem. I'm gonna research it." I might just start on Google. Criminal procedure treatise. First thing that comes up, Georgetown Law. It's a general matter, .edu sites tend to be somewhat more reliable than other sites. So here's Georgetown Law, whole list of criminal procedure treatises. And you can see some of these are ones that you all used, whether it's the Nutshell, whether it's Lefebvre's criminal procedure, 7-volume treatise. So I might look through these and think, okay, well, here's a 7-volume treatise on criminal procedure. That sounds like it's probably going to have what I'm looking for. So then I go to the library, and maybe I look up the call number for criminal procedure by Lefebvre. Or maybe I can't find the call number, and maybe I ask a research librarian for some help finding this treatise. Okay. Let's practice the researching. And then after we practice, I'm going to give you some more tips. Right? But imagine that a client comes in, and the client says, "Oh, I really need an attorney, and here's what happened to me. Here's what happened to me. Let me make sure I have all the detail, the facts here for you." I am I want to know, I'm a client, I want to know if a public high school can make male basketball players keep their hair short if it doesn't make female basketball players keep their hair short. So in other words, client comes in and says, I am a male basketball player at a public high school. And they tell me I have to cut my hair short in order to be on a basketball team. And I say, okay, that seems okay, so long as the rules applied equally. But the school doesn't apply equally because it doesn't make female basketball players cut their hair short. And so I say, because it's a public high school, this seems discriminatory. The government is discriminating against me because of my gender. And you as the attorney say, well, I'm not really sure that you're right, but I'm going to do some research. So research. Work with the person next to you. Use your laptop. So you have a laptop. If you don't have a laptop, feel free to work with someone who does. I suggest you go on Lexis. Go on Lexis for today. Try to find the answer to this question. Take about 5 minutes. And then we'll talk about how some of you found the answer, if you did. Talk about the marathon sprint. But let's talk about what worked and what didn't work. So Sharia, I saw that it looked like you did a fairly natural language search. So tell us word for word what you typed in there. I'll type it in here.
Can public high school make male basketball players keep their hair short? If it doesn't make female basketball players keep their hair short.
So, Sharia typed that in, and Bryce too. I think they were working together. And the very first case that came up is this Hayden v. Greensburg. Here's the overview. Public high school's policy requiring boys playing interscholastic basketball to keep their hair cut short deprived appellant's son of equal protection by discriminating against him on the basis of sex, as the policy did not apply to girls playing basketball, and the record did not supply a legally sufficient justification for the sex-based classification. Which is a long way of saying that the boy won, and the policy, it was found by the court, at least. I'm not saying the court was right, but it was found by the court to discriminate against the boys. So I have to say that I'm stunned by how, I'm not going to say how stunned, how good you were, but because I expect you to be just terrific. I'm stunned by how good Lexis's search engine has gotten, especially in a Google type way, because I don't want to sound like a 1,000-year-old person here who had to look on papyrus for legal research, but there is no way that search would have worked when I was a 1L, or when I was a junior attorney out of college or out of law school. It used to be that you had to know how to use the terms and connectors that I think Colby talked about, and that I emailed you yesterday, the day before. And a natural language search like this would have just totally confused Lexis. But I'm glad that Lexis has improved. Welcome to the brave new world. Count yourselves lucky to be in the year 2018. And to the extent this works, when this works, that's great. You should use it. Don't make life more difficult. I want to show you how to use terms and connectors for when natural language does not work. Because I don't want your research success to hinge on a search working that might not work always. So let's walk through what a natural language search, what a terms and connectors search might have looked like. So we'll start with this search. And here's what I typed in. Equal protection, that's in quotes. Shelby Boyd, what do the quotes mean? What do the quotes tell us?
It keeps the whole phrase together.
Yep, so if there's a case that says equal somewhere and protection somewhere else, that case, but never says it together, that case is not gonna come up. So equal protection, within the same sentence, that's the W/S. So you could have just said, okay, I want a case with equal protection and gender or sex, but that might give me too many cases. This one says, I want the case to be so connected, equal protection, gender or sex, that it's in the same sentence. And then note here, gender or sex, this also used to be a huge issue on Lexis. Synonyms. I think that their natural language searches now on Lexis, they account for synonyms, but it used to be that, if you searched for equal protection within the same sentence as gender, then if the judge used the word sex instead of gender, you were out of luck, that case wasn't going to come up. So equal protection with the same sentence as, and then in parentheses, gender or sex, so you're covering your synonym there. And then at least 10 times gender or sex. So we don't want a case that just mentions gender discrimination once. We want gender or sex to be mentioned at least 10 times. And then we also want it to be mentioned within the same paragraph as a school, because we don't want discrimination cases outside of the school context. So, this narrows it down to 1,400 cases, but that's still a lot, and that case that Showery found and Bryce, it's not coming up right away. It's not coming up right away. So, we could narrow it even more by using even more terms and connectors. So, let's see. So now we've got equal protection, same search, but then look, I've added this. Sorry. I've added this, at least 10 times school. So we don't want just school gender discrimination to be mentioned once. We want to make sure it's mentioned at least 10 times, the school. And we don't want a bunch of cases that are dealing with college and universities, because they might have a different inquiry into what discrimination counts, what discrimination looks like compared to high school. So, and not college and not university. And so then we scroll down, and the second case we find is the Hayden v. Greensburg case. So, all these terms and connectors got us where the natural language search got us. Feel free to use the natural language search. I'm not saying you shouldn't start there. But if the natural language search doesn't get you where you're going, it's important to know how to use parentheses, how to use the quotation marks within a sentence, within a paragraph, the difference between and, or, using the and not terms and connector so that you don't get a bunch of irrelevant cases. All of these are important tools to be able to use. Okay, questions? All right, let's talk research in general. Okay, when you are searching, let's say you do a search and it brings 100 cases. You think you should read every word in those 100 cases in order to find what you're talking about? What about you pull up a case, its overview looks mildly relevant, but it's a long case. Let's say it's a 50-page long case. You don't want to read every word of that. Let's see, Sam. Oh, Sam's not here.
Yeah, I'm over here.
Are you over here? Okay.
Yeah.
What's a way to quickly look for an important term in a long case without reading every word of the case.
Can you just search the document?
Yep. So Control F, Command F. Let's say you want to, you're looking for like hair, hair length or something like that. Let's do that. When to stop? We talked about this a little bit earlier. Don't stop too soon. Don't stop too early in terms of how much research you're doing. Too soon, there might be better cases out there. The next page of the treatise might, explain some difference in Brady law that you didn't know. But you also don't want to stop too late where you're just compiling cases after cases that are adding nothing. Say the same thing you already have. How do you know? It's hard. It's hard. Practice helps. As you're researching, it's not useful to just like read a bunch of stuff and then forget it. So obviously take notes. The way I do it, I keep a Word document and I cut and paste. And I make sure that I use quote marks. I make sure I use cites so I know it's not my word, but I'm doing that kind of madman building ammunition thing. Let's see. What if you run into research problems? So, Sharia. Let's imagine that you do a search on Lexis, you don't find the case you're looking for, you're finding too little. What can you do?
You find a case on Lexis and you don't find what you're looking for.
Yeah, let's say that you were looking for, well here, let me give you a hypothetical. Same thing as the hair basketball player case. And let's say I told you we were in Kentucky, we're going to sue in federal court. And so let's say you start out looking in the Sixth Circuit, which is our federal circuit. So it's going to pull up Supreme Court cases, Sixth Circuit cases. All those you're going to be controlling. And let's say that you searched something like hair length, gender discrimination, and you're getting like a total of 20 hits, and none of them are really helpful. What are some things that you can do at that stage?
I'm not sure.
Any guesses? What would you do? Yeah, Dimitri.
I mean, we get like thousands of hits, so I would love to have that problem, kind of. But
You would what?
I would kind of like.
You would love to have that problem? Yeah, we're gonna get to that problem in a minute.
But I would just be more general, I guess.
That's exactly right. So if you're getting too few hits, expand your search terms. You're probably being too picky. And then also in my hypothetical, I said you've narrowed it to the Sixth Circuit. Well, if there's no Sixth Circuit case on point, look for some non-controlling cases. Like a persuasive case that's on point is still better than nothing. So don't just limit it to your jurisdiction. And then also call Lexis. So hopefully Colby gave you his number, his email address, or at least told you how to find it on Lexis' website. He can help, and then Lexis has paid research assistants who are there to help. It's their job. So don't hesitate to use that resource. Okay, now let's imagine that you have the problem that Dimitri's talking about. You found too much, right? 1,000 cases, I'm not hungry, 1,000 cases. It's unclear to me like which of these might be better than others. What can you do? What can you do, Kelsey?
You can like add terms that are more specific.
That's exactly it. Narrow your search terms. So keep the search terms you had before. They've narrowed it to 1,000 cases. But then add some search terms that are going to narrow it down to 200 or 100 or 50, something manageable. And you can get more picky about jurisdictions and courts, and also you can call Lexis. Okay. Yeah, sorry.
Yeah, he showed us this method like the top left, like you click browse and then you go by like jurisdiction or category. You know what I'm talking about?
Yeah.
Like that right there. Do you recommend that? Like, do you think that's useful?
I think it's all useful. Like, especially when you're just beginning, then I love starting with a secondary source. You can start browsing secondary sources, narrow it, from all treatises in the world, criminal procedure treatises, and then search within that limited universe for the Brady case, something like that.
And why is secondary sources the most important? Don't you want to find the most like controlling and?
So that's a great question. Secondary sources are not the most important. they're sometimes the best place to start, but they're never the most important place to end. So you're looking for a controlling case, maybe you'll type in a great Lexis search and that just sends you right there. But maybe not. And using a secondary source allows you not to reinvent the wheel. Someone else has already done that research for you. So don't use a secondary source and stop there, but use a secondary source to lead you to a primary source, and preferably a primary source that's controlling. So let's say that you're researching your Brady case, and you've now done the research that you did, you went to a secondary source, you have a general idea of the Brady test, but now, you know, that Lefebvre treatise, you know, it mentions some key Brady cases, but not necessarily one that's exactly on point for you. So here's what I would suggest you do as part of your research for your memo and to prepare for your outline. So I would just Google Brady. I find the citation 373 US 83. I put that in to the Lexis search engine. What is that going to do? Now if I just used no quote marks, it would have taken me straight to that case. But with quote marks, it's going to tell me every case that has ever used that exact phrase, 373 US 83. That's every case that has ever cited Brady. 10,000 plus cases. Obviously, way too much. But we're in the DC Circuit, so I'm going to go over here and I'm going to narrow it to DC Circuit. 402. So it's still a lot to navigate. So maybe I'm going to change it to at least so it mentions Brady at least 10 times. And once again, narrow this to DC Circuit. So now we're down to 119 cases. Now, is that still a lot to read through? Yes, you shouldn't read every word of 119 cases. But can you read can you read 119 sentences? It's not like the most Herculean task. So you can read 119 sentences, which is another way of saying read 119 overviews as you scroll down. And look for something that you think, oh, you know, this seems somewhat analogous to my case. Analogous to my case. And then if you find something you think is somewhat analogous to your case, you click on it, you dig a little more in depth. See if the same legal moves that went on in that case are going to affect the outcome of our case. So, just to be super clear, for your research, for the outline you're doing for October 15, 16, 17 in our meeting, you know, it's not the end of the world if you don't find the most analogous case, but you should at least try this search. And then also experiment a little with how Lexis is sorting. So sort by relevance. You could sort by date, newest to oldest. And then you also can narrow to the extent you think of some search terms to narrow by. But don't make the mistake that I was talking about with Dimitri and Sharia, narrow too much and exclude the cases can be really helpful to you. Yeah.
So if we knew when because you said the law changed a little bit.
What did you say?
You said the law changed a little bit, the Brady case.
Mhm.
So if we knew when that was, would you eliminate all of the cases that cite it before?
No, not really. And let's think about why that would be the case. The thing that changed in the law, and I think it was a case called Agurs, A-G-U-R-S, that tweaked this was instead of the defendant having to show that favorable evidence was withheld that's material to the case, and that evidence was requested by the defense just now has to show favorable evidence was withheld as material to the case. But, the question in our case might be the key question that the court will be confused about unless you find good research, is was the evidence in our case material? And in order to prove to the court the evidence in our case was material, you're going to need a precedent that that you can use to say to the court, hey, court, this evidence from this precedent was material, and our evidence looks a lot like that. Now that analysis is independent of the question of whether or not the evidence was requested by the defense. So even though, let's say that you find a case that's very analogous on the materiality question, even though it was decided before the court said defense has to request evidence, that analysis is going to be extremely useful to you today. Does that make sense?
Yeah.
Okay. On the other hand, though, one of the elements is, was it withheld? Was the evidence withheld by the prosecution? And sometimes when courts were explaining the rule explanation for withheld, they kind of worked that old requirement. Well, it doesn't count as withheld if the defense didn't request it. Well, that should not be part of your explanation of withheld, because that rule is no longer the case. And in fact, when you're explaining what it means for evidence to be withheld, it would be useful to say, as part of your rule explanation, it's withheld, it counts as withheld whether or not the defense requested it. And then when you're doing your rule application, if you're doing rule application for a client where the defense did not request it, you can make that part of your rule application. In our case, the defense did not request the evidence, but that doesn't matter because you cite the case that says it doesn't matter. Make sense? All right. Let's end with a Garner section that we have not read yet, but that does not take more than a second to get the gist of.
Page 27.
Read section 6, but stop on the next page when you get to, when you finish the first, when you get to the first block. So you're really only reading 7. Stop when you get to the John Austin quote. To do intermediate question number 3.
No, you got it.
I don't want to.
The one that begins
Thank you, right.
sometime subsequent thereto. And the instruction that Garner gives is rewrite the following passages to make the average sentence length under 20 words. So this does not mean every sentence has to be under 20 words, but it could be average sentence. To find most of the things that you will need to cite for this class and just as a lawyer. Basic cases, short forms, federal and state statutes, books and law review articles, unpublished opinions. So bring this to class every day. For the rest of the semester, bring this to class every day. And when we do the online exercises, you can use this. I won't have to tell you, oh, it's on Blue Book page 14, which is when you're actually practicing law. Fortunately for you, I will not be there to tell you. But the sheet can be there forever. And then the second thing is court abbreviations. So I've referred to this a few times, but now, it's the real deal. You're one step closer to being actual lawyers. By the way, 2 students from my first class that I taught are being sworn into the bar today. They found out they passed on Friday. Most people are being sworn in a few weeks, so they're doing this early today. And they see it. I am beyond thrilled. I'm so happy. I'm presenting all that. And I was instructed by Justice Hughes to keep the presentation to 1 sentence. He said, one time, a new lawyer's dad spoke for 7 minutes in presenting his daughter. So 1 sentence. But you just saw from this case how long 1 sentence can be. So Oh, by the way, I also love doing this exercise with Garner because you all read this case, right? I heard you all talk about it.
And towards
So, like,
intensive.
it's another example of a case that is in your casebook for great reason, important legal principle, but it's in there in spite of the fact that it's horribly written, okay? Okay, court abbreviations. When you are doing a Blue Book site, you need to tell the reader what court the case came from. In the past, when we practiced, I just told you the abbreviation for the court. So like United States Court of Appeals for the DC Circuit, I've been telling you on the board, DC space SIR period. Now, I'm not gonna do that anymore. You have this, you should bring this to class every day. Bring this to class every day. And what you do is, first you just figure out, is this a federal court or a state court? If it's a federal court, you start right here, and it lists them all, courts of appeals, the district courts in order of hierarchy, and then by alphabetical. You go to state courts, they start on page 503, they're just total alphabetical. Alabama last year is on our. So all you need to do, let's just practice 30 seconds. So Kelsey, imagine I want you to cite a state court. It's the Colorado District Court. That's all I'll try to find that. Colorado District Court. You need to know the abbreviation for it so that you can put it in your Blue Book site. Okay, just say it out loud.
Okay, I like that. So now what's the difference between district?
Yep.
District.
Yep, great, Kelsey. It's page 503, so what Kelsey did is she skipped all the federal courts, because we're not doing federal courts. She went to state courts, she went alphabetical, so she got to Colorado on page 503, she found Colorado District Court, and that's it right there.
Okay.
So, very doable. Now you're on your own. All right, I'll see you on Friday.